Important. Yesterday, 2 days back it was out. You know this case? Sir, do you know this case?
I think somebody has asked for the thumb impression of the
I lived very near Parapanagarahara, where Jayalalitha was in jail. So Jayalalitha was in jail. She put her thumbprint before going to Parapanagarahara jail, right?
Madras High Court has denied.
No, I'm just, so she put her fingerprint, right? Then there seems to be, the opposition is saying that there was an incident in which Jayalalitha was actually physically present. Jayalalitha's counsel is saying that no, she was not there, she was in the jail. Okay, now how can you prove? Right? So you have a thumb impression, right? But I have to match it with Jayalalitha's. How will you match it with Jayalalitha's? She is dead. She is no more, no. Last year she passed away, right? So High Court asked for release of biometric information from the Aadhaar database of Jayalalitha so that they could match it. Then if it is proven, then she was in Parapanagarahara jail. If it is not proven, then she might have been in another place, right? High Court asked for release of UIDAI biometric information. UIDAI came back and said that the biometric information cannot be released without the owner's consent. Owner's consent. You cannot get it anymore, right? So Supreme Court, it went up to the Supreme Court. So Supreme Court said it has put a stay on High Court questioning of this. No more information releases about Jayalalitha, especially on fingerprints, and it has stayed the proceedings. Very important, right? How will you account for this? Is this okay? There is something called as right to be erased, okay? And we will discuss about that in e-GDPR. So if, for example, once the person is no more, should that information be there or not be there? It's a big question mark which is haunting UIDAI, right? Now, on one hand, you cannot get the consent. On the other hand, you cannot release without a consent, right? So how will you do with this? It's a big problem, right? So how will you deal with all these things? It's a big question mark, right? So we need laws, regulations, and policies, okay? So snapshot is not, we have been having a lot of laws, right? So Indian Telegraph Act of 1885 also talks about privacy, right? So it takes service providers, but here who is providing the electronic communication, electrical and electronic communication, they cannot without authorization snoop in or intercept communication, right? This is there in the Telegraph Act. So if, for example, a telecom company such as Vodafone or Airtel taps into your conversation, then it is against this particular clause in the Telegraph Act, and they can be booked for unsolicited surveillance, okay? We also have Information Technology Act of 2000, amended in 2008, has a lot of clauses, but the important thing to note is that each law has its own focus, each act has its own focus, right? Telegraph Act is mainly intended for service providers. It does not care about individuals. It only worries about service providers. What service providers can collect, not collect, should they protect, should they not protect, and most of this is related to surveillance, that is during the information collection stage. They are not, it's not worried about how it is passed on, it will be passed on and it will be aggregated and things like that. It's not worried about all these things at all. It's just worried about the surveillance part of it. So we are just covering about, I don't know, 1/4 of the whole information taxonomy, privacy taxonomy that we discussed, right? Information Technology Act, it has clauses for breach of confidentiality, security of information by the service providers, disclosure without consent. These things are addressed, but it does not even talk about secondary use. It does not talk about aggregation. It does not talk about accessibility. So all these things are not covered in the Information Technology Act. Just bare minimum, you have to keep the information secure. Nobody can actually access this information without your prior consent, and things like that, right. So, only 2 or 3 clauses are covered in the Information Technology Act. Then we have Aadhaar Act. In fact, Aadhaar Act is very good, I like it very much, and it is actually targeted delivery of financial and other subsidies and services act, right. It's got nothing to do with your bank account or income tax PAN linking and things like that. So, it's for targeted subsidy, right. It's actually enacted under finance bill, if you remember. And then if you look at the act, it mandates responsibility of the requesting entity, that is whoever is collecting your biometric information or who want to authenticate your Aadhaar number to use that information primarily for authentication. So, according to this act, anybody can authenticate, but there's only the answer should be yes or no, right, whether you are what you are or not. The important thing about Aadhaar is that Aadhaar links your random number to your flesh and blood. That's the most important thing, right. No other instrument links your flesh and blood with a number, your PAN number. That's the reason why we have many PAN numbers, no, all belong to the same individual, but cannot be linked to the flesh and blood, right. Bank account, you can have many accounts, no problem, right, but Aadhaar number you can only have one. It's a one-to-one relationship, right, because it is linked to flesh and blood, right. That's why it is very powerful, right. So, Aadhaar Act recognizes that, right, that this biometric information should be used only for authentication purposes and not for anything else, and the requesting entity has to be very careful, right, when it is using Aadhaar related information. It cannot be used for secondary use, it cannot be used for aggregation. All these things are discussed in the Aadhaar Act, okay. So, it discourages secondary use, for example, whatever we have discussed, right, without one's own content cannot be used for purposes other than for which it is intended for, right, and Aadhaar is mainly intended for cash transfer, direct subsidy, government services, and not for anything else. So, there are a lot of clauses which prevent that. So, but the focus area is, I mean, it's a little bit broader compared to, for example, the Information Technology Act or the Telegraph Act. It covers areas such as confidentiality, secondary use, disclosure, and so on and so on. So, it is a little bit broader in scope. Then we have this famous Puttaswamy versus Union of India judgment, Supreme Court judgment, right, which came out on 24th August. So, what does this say? This says that the privacy is a fundamental right of every citizen. It's a fundamental right, right. So, protecting the privacy is a right for the individual. It's a very simple statement, but it is very powerful, right. So, what does it say? It basically says that right to privacy is protected as an intrinsic part of the right to life and personal liberty, a part of the freedoms guaranteed by Part 3 of the Constitution, right. Except under reasonable restrictions, you can defend your privacy, and that is very important, right. So, tomorrow, for example, if you think that your Aadhaar linking is being used for secondary use or for aggregation purposes, you can actually file a case. Am I right, sir? I can file a case saying that it is my fundamental right to protect privacy, and I can take recourse under this particular judgment, right. So, today, so it is not, it does not go into all the details, right. I mean, it is like 270 pages or something. I have not fully read through it, but the focus area is the state cannot surveil you. It is mostly on state surveillance, right. So, if for example, you are UIDAI, nobody can force you, right, to disclose your UIDAI information, and that is one of the reasons why now government is very cautious about doing many more things, right. Even Aadhaar linking with your bank account, PAN cards being postponed 31st March, and in fact, it is coming up for hearing in Supreme Court soon, right, whether it can be done or not, and things like that are being questioned. So, whenever government formulates any act or policy, then they have to be conscious of the fact that it can be contended by the individuals in the court of law, right, and therefore, it provides us with that mechanism, right. So, even though it is very simple, it provides you with all the ammunition to go to the court and protect your individual privacy. That is one of the important things that this particular judgment has done. And of course, recently last week, the Justice B.N. Sri Krishna committee report is already out, that is the draft data protection regulation. So, this is supposed to give us combined view of all the things that we discussed. I don't know, I haven't read it, it's about 273, I am still reminded of the 273 pages, how will I read it, right? But if you happen to read this, right, this is up in the MIT site, the Ministry of Electronics and Information Technology website for public consultation. You should all read it, right? And then it's open for consultation, and after that it will be drafted as a bill, and then it has to be enacted in the parliament. But we have some, good things that have come together. I mean, so far there was no protection of privacy in the country. You cannot really protect your privacy. After the Supreme Court, you can protect your privacy, and but under what? It is still very nebulous. There is no definition of privacy in the Puttaswamy judgment. It doesn't say what privacy is, but you can file a case and you can defend against your privacy violation. But this one goes into the details of what constitutes privacy, and therefore you can actually make forceful arguments, right, if there is any violation and so on. So we have to I haven't gone through it, but important thing, what about other countries, right? Are we again lagging by 60 years, 70 years from other countries? Yes, we have lagged quite a bit, but the recent Supreme Court judgment is being praised all over the world, right? This is the greatest privacy related legislation which has come. So the important thing is the other countries are looking at it. An important thing which is happening is the General Data Protection Regulation Act of the European Union, which is coming into force on 24th of May 2018. This is very strict, okay? This protects the privacy of the individuals, and more than that, I have circled some important aspects of this GDPR. The important aspect is right to erasure. Very important. If I think that my personal data has to be erased, and if I go a query to Google, then they better delete it. Delete it from all histories and all databases. All around the world they have to be deleted. And I have the right to be forgotten, right? The need to be forgotten is very, very important, right? And it is very, very difficult to implement even with algorithms that Professor Shisharov discussed, because it might be there in thousands, millions of places. But I have the right to erase that particular information. That's a very important provision in the European GDPR. I have not yet read that Sri Krishna report. I don't know whether it is there or not. I have to see that. But if it is there, then all these government as well as firms which are collecting information have to seriously look into it, right? Because this clause is very, very powerful. The second important thing is international data transfer. So as you know, the information technology services industry, the keynote speaker talked about all those things. We deal with information all the time, right? Our IT companies like Infosys, Wipro, all the BPO companies, they handle personal information all the time. The important provision in the EU GDPR is that it gets the privacy of the individuals gets carried across countries. Data sovereignty is. So, for example, the EU related data, if it is handled by the data aggregator in India, then we are subject to the same provisions of privacy compared to, for example, in Europe, right? Which means that our companies have to comply with the EU GDPR and make sure that privacy violations do not occur. The important thing, see, we can have all these policies, regulations, but there has to be enforcement. That is one where India lacks quite a bit. There can be a lot of regulations, lot of rules. Our rules and laws are always perfect. But the problem is with enforcement, right? Important clause here. Companies tend to lose 2% to 4%, am I right, sir, of their gross revenue if there is a violation under EU GDPR. And that can be millions of dollars for companies, even billions, right? Google has to be really, really worried, right? Before 24th March, if there is a case against Google and Google is found to be violating EU GDPR, then it has to pay up to 4% of their profit, of about $70 billion, right? So it's a serious violation. So the enforcement, the most important thing is EU GDPR is the first global regulation where enforcement is given preference. Okay, So which means that if you don't adhere, then there is a serious penalty, and therefore the companies will weigh what is the benefit that I am getting by manipulating user data, what is the penalty that I will pay if I am proven wrong, and therefore they will make appropriate decisions, right. So EU GDPR is the first major step in global regulation. So again, there are focus areas in EU GDPR. If you look at EU GDPR, mostly it's about exclusion. If I want to be excluded, then I have a right to be excluded. Right to be forgotten is very given prominence in the EU GDPR. It is not touched at all, Information Technology Act or Aadhaar Act or any of those things. That's one of the reasons why, for example, Aadhaar Act is not able to decide on Jayalalitha, no, because Jayalalitha did not say that I have the right to be forgotten, right? So we have to carry it along. So that's a problem. Disclosure, confidentiality, all these are given prominence. Surveillance is not given prominence in GDPR because EU GDPR is mostly about private information, right? And the organizations which deal with private information. So what we have discussed is there are laws and regulations, and these vary in terms of focus. And ideally we would like to have a law, or our new data protection regulation bill should cover all the other aspects of privacy. That the whole taxonomy has to be covered, and there has to be a clear way by which I can articulate when my privacy is violated, which bucket it falls in, so that it is easier for the judgments to take place. Otherwise judgments will take long time, and therefore so I have tried to map, for example, the security policies and acts along these different dimensions. You see that there is a lot of whites, right? These whites are not covered, so it's very, very important for us to cover. Another important thing that Aadhaar Act to some extent covers exclusion, right? Exclusion means either to be excluded or to be included. Okay. In fact, Aadhaar Act, you can get an Aadhaar number. I mean, it in fact has a provision for homeless to get Aadhaar number. That is inclusion, right? For example, it is basically Aadhaar provides you residency, right? If you have a residency proof, then you can get the Aadhaar number, because Aadhaar basically enables you to be authenticates you as a resident of the place where you live in, right? If a person does not have home, then he cannot give address, right? It's not possible to get the Aadhaar number, but Aadhaar Act has a provision for inclusion of people who don't have homes, right? So which means it's a landmark act, which does not exclude anyone, right? That's the most important thing. So like this, different acts have their own preference. I have created the greens and the darker ones, or where the it stresses on, and so on and so on. There are a lot of white spaces that we need to fill up in our regulations and policy going forward. Now, important thing, right? So there are a lot of ways to deal with this. One is through regulation, government intervention, right? Can it be solved by markets? Can it be solved by markets? Like every market, right? You have information market. There is a new term called I-commerce which is coming up, right? Information commerce. So each and every individual can assign property rights to individual information, right? So my name, my Aadhaar number, mobile number, address, some things I will trade with Google, and for that I will get some money. Like this, can information markets exist? There's a lot of research which is going on at this point of time. So we might come to the stage where we will be willing to sell our information, right, for getting some benefits. It's possible. In which case, the markets might actually self-regulate. If I don't want to get the benefit of the market, then I will not sell my information. If I am able to get it, then I will sell that information, right? So it is possible that a market might actually develop for personally identifiable information, right? Yeah.
Why would that happen when they're right now able to access all the information?
Yeah. So along with that, there will be restrictions. For example, you can define what should go, should not go. So those mechanisms have to evolve.
Already divulging.
Correct. It's okay. So for example, I mean, we all know that information has some timeline. So it's okay. I mean, the past information may not be very useful as the current information, and therefore I can create an information market based upon current information.
And also these kind of policies, European one or the new regulation is you can't use it. So after that,
Right.
then there will be a possibility
As a
of
reaction
new
to
map.
that.
Right. So, people are thinking along these lines, because all the time you put the onus on the government to do something, government may not have wherewithal, right? Government may not have the expertise to do that, right? Is it possible that it can be solved by markets? That's another view. Economists are saying that information is like any other good, so there has to be a market, and therefore let us use economics to create markets for information, right? So those are all some new aspects which are coming up. So this is data is an asset, and therefore careful use of data is warranted to protect privacy of individuals and so on. So we touched a little bit, for example, there are a lot of aspects to privacy, right? So we discussed about, for example, the technology. There are legal angles, social, political, and economic angles to privacy, and these have to sort of converge in order to create a holistic privacy regulation. But as we know, most of these regulations and policies that we craft, they cover only certain aspects, but a holistic dimension, holistic view is required. So that's about my talk, and you have references here, so you might have to look at it. If you have any questions, you can ask me. Any questions? 10 more minutes on time. So any questions on privacy and regulation? Yeah, Shushavi.
So you talked about the right to provide.
Yeah.
So definitely there can be attempts to erase data from different kinds of databases around the world. But really lots of models have been trained, right, with all these people's data. So how are you going to propose to erase such data? Because you can't really pick one person from a model which has been trained.
Yeah. So it is very unclear, to be very unclear. For example, EU GDPR has this particular provision, right? Now, how the governments are going to do it, what kind of a mechanism should be implemented is very open, but it is possible. I mean, the way in which we created, we should be able to destroy it. There is a way by which we created it. So if we do reverse engineering, we should be able to destroy it.
So what circumstances when the process of destroying it's like kind of way train ones that only that essentially only that one particular data might not be lost, but several other data points as well.
Correct. So it's not very clear how the firms will accommodate. We have to say basically solve the first question which comes up, right? Somebody says that I want the data to be erased. We have to then take this use case and see how the companies are going to do it, right? So for example, there is no provision in the Aadhaar Act, for example, to delete biometric information. If the person is no more, it's not automatically deleted. There is no validity period for Aadhaar. Am I correct? There is no validity period. Yeah.
In your last slide, you are mentioning about having a comprehensive data set. In your view, which department of the government should be taking this up?
Yeah. So that's a very important question. See, as Ministry of Electronics and Information Technology has put out this draft regulation bill, Telecom Regulatory Authority of India has already released a consultation paper, and it is going to come up with its own recommendation of what the telecom service providers to do with respect to data protection and privacy, right? One of the reasons is that the chairman of the Telecom Regulatory Authority of India was with UIDAI earlier. So he strongly believes that it has to come under the Department of Telecommunication, right? Because telecommunication, internet and all those things are linked together, right? So it is a very, I really do. Correct. So, yeah. So, in my view, okay, because it is related to digitization, it has to have a combined view of the Department of Telecommunication and Ministry of Electronics and Information Technology, right? And it is not possible to prescribe actual solutions privacy violation in each and every case. So I believe in ex post regulation. Ex ante can be only for basic things. Ex ante means you have a regulation which everybody has to abide by, right? But that can be very restrictive, right? It can prevent innovation, for example. I cannot say that you should not use secondary use. Data should not be used for secondary use. Then in which case all the information markets will collapse, Google will collapse, right? Go and you might have to pay 10 rupees for each search, which you don't want, no. We want free search, right. So, ex ante regulation should be sort of minimal, right, and then I believe in ex post, right. So, whenever a case comes up, then it has to be analyzed on the merits and demerits, and then the decision should be made, right. Now, it can be handled by courts of law, or it can be handled by Competition Commission of India if it is relating to firms and the abuse of the market power by the firms, or it can be by the individual sector regulator. For example, if it is telecommunication, TRAI can take it to TDSAT, the Telecom Dispute Settlement Appellate Tribunal. So, it can be distributed, it need not go to Supreme Court all the time, no. So, we need to have a mechanism by which it can be sectorally decided, right. If there is a financial breach, then SEBI should take the call, right. If there is telecom violation, then TRAI should take the call. If it is Competition Commission of India should. So, I believe in it should be exposed, ex ante may be very, very restrictive because it is very dicey. Yeah.
So regarding the Aadhaar, so if you are going to take, if you are going for a new SIM card or something, so you have to do the Aadhaar verification first time. So the person, like the shopkeeper, can access the information, like he can view the information, like if I am giving the biometrics, he can see my personal information.
See, I mean, this is not very clear, the requesting entity, initially when the whole UIDAI was designed, it is only for authentication purposes, which means the requesting entity can ask whether it is in the database or not, yes or no. The answer should be yes or no, not giving all this date of birth, blood group and all. So, today it has been relaxed, because if you do KYC for a mobile company, the mobile company needs not only yes or no, but also needs address, right, and therefore they started providing APIs by which you can have access the application program interface, by which this requesting entity can access the information relating to address and so on. So, some information they let it private, not the date of birth, but address information, right. So, they are able to get that, right. Now, it is okay if it is used only for KYC by the telco, but if that telco sells it to another one like insurance agency or retail store, you get a mobile SIM from RGO and you get a coupon from Reliance Footprint, it is secondary use, no. So, if that is used, then it is a violation. So, but they are quite restrictive, I mean, in the sense that not all.
We can see the email IDs and all.
Correct. That is because of the requirements for which it is used. See, if you have direct, I mean, the Aadhaar Act is not a act which covers all the sectors. It's only for financial services provided by the government subsidy services, right. So, if it is only for that, then you don't require these kind of information, right. You need to be authenticated whether you are a correct person or not. But unfortunately, if it is used for KYC by a mobile company, then you need some more information, and therefore, the APIs have been, are allowing all this information to be sent and so on. So, it is still in the code, I mean, we have to see whether it is.
If I am selling like 5 or 6 SIM cards, so I can access the old information, like, as you said.
Correct.
So, even I can sell it.
Even otherwise, you are access, no. See, even otherwise, in the KYC, what you asked to fill up all the, you can take a copy and do it, no. So, there is no violation. I mean, see, the important thing is whether we are doing the same thing as we were doing it before, or much less, or it's a compare. So, even before, you had all the information. The retail shop had all the information, because you need to fill up that form. You give. Correct. So, because mobile companies have started using for KYC, which required more than the approval, the application programming interface allowed to access this address information and so on, right. So,
and they will not dilute the biometric information, not the.
No, biometric information is ruled out. I mean, this biometric information.
KYC, whether it is bank or PAN, automatically it goes up invariably.
So, the case, no, like dog getting Aadhaar number and all. So, you can spoof biometric information, and you can actually, there are cameras, high resolution cameras that can actually mimic, I mean, the photographs can be captured in such a way that you can mimic the other person and then get, so, latex fingerprinting, correct. So, you can do latex fingerprinting, so you can spoof the machines, but technology can evolve in order to minimize the spoofs, right? Yeah.
Question. So, like in the enterprise software space,
Yeah.
there are kind of guidelines out there. So, companies like
Correct.
they put out guidelines which basically say enterprise security. Here are the safeguards to make sure the secure software is not hacked. So, similarly, is there such thing on the app in the app space a minimum safeguards to make sure whatever app you publish isn't breached, compromised, and customer data? Anything available like that internationally?
See, yeah, so it's a good, I don't know, you might want to ask Professor Srikanth when he comes here, but in general, the minimum checks are being done when you upload the app to Play Store or the Android iStore, right? So they do the sanity check to make sure that there is no vulnerability in the application, right? The vulnerability that can actually breach the user information.
Apple doesn't give a set of guidelines or anything.
It is there definitely. It is there definitely, and you passing the check on an iStore is relatively difficult. I mean, you have to pass all the sanity checks before it gets approved to be there on the iStore. Google's check is a little bit loose because it's an open source platform and things like that, but they also do sanity check, right? But I don't know about the standards, which what standards they use. Might want to ask. Do you have any idea? The standards for mobile security, mobile app security, but it's only at the store level that it is done. Yeah. Any other questions? We have almost done. Any questions? Yeah.
So, you mentioned e-commerce.
Yeah.
So is there any, in first look it looks very advantageous to everybody, but is there any drawbacks of it?
See, the drawback with markets is that markets can become imperfect, right? If it is a competitive market, it is a perfect market, then Adam Smith said that invisible hand will take care of everything. You don't have to do anything, right? Who is from economics? Von Carmel. Yeah, right? So Adam Smith said, but there can be imperfection in the market. The imperfection can be due to monopoly power. For example, Google can dictate because it has 90% of the search queries, right? Or it can be because of externalities. For example, the information asymmetry is a positive externality to the firm because you leverage this. So if there is an externality, positive or negative externality, then it can create imperfectness in the market, right? So if there is imperfectness, then the market will not work. Then government has to intervene or regulation has to intervene. So we don't know really, for example, whether the e-commerce market is going to be perfectly competitive market or not, right? So we need to see it. For example, search market is not competitive. That's why EU has put a penalty on Google, right? Because it manipulates search results. And why? Because it has monopoly power, abuse of monopoly power. So it's not a perfect market. So we need to see how, for example, the e-commerce is going to evolve. But my guess is that there will be more suppliers, more, in general, anything to do with information has no great barriers to entry. That's why we have millions and millions of apps in the App Store. So if those are there, then invisible hand will take care of it. Yeah. Okay, I'll close it. Yeah, thank you.